Nature and effects of obligations. Goal. Ma-explain ang pagkakaiba ng generic at specific obligation. Ma-enumerate ang mga obligasyon ng debtor sa bawat uri ng obligasyon. Ma-enumerate ang karapatan ng creditor para sa bawat uri ng obligasyon. Maipaliwanag ang mga konsepto ng fraud, delay, at fortuitous event. Sa video na ito ay tatalakayin natin ang una at pangalawang item. Ang pangatlo at pang-apat na item ay sakop ng ibang video para hindi masyadong mahaba ang video na ito. In our previous video, natalakay na natin at naipaliwanag ng mabuti ang Article 1156 to Article 1162 ng Civil Code of the Philippines. Kung hindi pa kayo nakakapanood ng mga previous videos, maglalagay ako ng link dito. Lubos ko kayong hinihikayat, panoorin din ito para mas maunawaan ninyo ang bagay na tatalakayin natin ngayon. Article 1163. Every person obliged to give something is also obliged to take care of it with the proper diligence of a good father of a family, unless the law or the stipulation of the parties requires another standard of care. Now, this provision actually refers to an obligation to give specific thing or determinate thing. Nagaya ng naunang natalakay na natin, it refers to the things that can either be particularly designated or physically segregated from its class. This is in contrast to obligations to deliver a generic or indeterminate thing, which refers only to a class or genus and cannot be pointed out with particularity. Let's take for example again, that same example with Ganda and Pogi. Pogi obliged himself to deliver to Ganda a Toyota Vios with plate number ABC 123. Dito, ang Toyota Vios na may plakang ABC 123 ay isang specific thing. Obviously, it was particularly segregated from its class. So now, gawin natin itong generic thing. It would then be, Pogi obliged himself to deliver to Ganda a car. Or pwede rin, Pogi obliged himself to deliver to Ganda a sedan car. And even, Pogi obliged himself to deliver to Ganda a Toyota Vios. Ang lahat ng mga yan ay tumutukoy pa rin sa isang generic na bagay. Gayunman, kung ang pahayag na ito ay gawin natin tulad nito. Pogi obliged himself to deliver to Ganda his only car. Dito, ito ay naging determinate or specific thing. Dahil sa salitang his only, meaning, iisa lang ang kotse ni Pogi. Hence, it is now particularly segregated from its class, right? At yung nag-iisang kotse ay ang pinangako niyang ibigay kay Ganda. So, malinaw na ang pagkakaiba ni generic thing and specific thing. Now, balikan natin ang Article 1163. Sinasagot ng artikulong ito ang tanong na, ano ang tungkulin o obligasyon ng isang debtor in an obligation to give a specific thing? And by reading the provision, malalaman mo na ang obligasyon ng isang debtor under obligation to give a specific thing ay, una, to preserve the thing. Meaning, pending delivery, if you are the obligor, kailangan mo itong ingatan at alagaan. Paanong pag-iingat ba? Ang sabi ng Article 1163, diligence of a good father of a family. Previously, we have already discussed what does diligence of a good father of a family mean. In simple term, ang ibig sabihin nito ay ordinary diligence. Hence, in preserving the thing to be delivered, the general rule is debtor must exercise diligence of a good father of a family unless the law or stipulation requires different standard of care. So, maliban na lamang kung ang batas o ang nakasaad sa kasunduan ay iba. Kung may ibang hinihingi na standard of diligence ang batas o ang mismong nakasaad sa kasunduan nyo. Like for instance, sa mga common carrier o yung mga engaged in public transportation. Sa kanila, The diligence required is more than that of a good father of a family. They are required extraordinary diligence. So, in an obligation to give a specific thing, diligence of a good father of the family ang required. Failure to observe that diligence ang nakakos ng damage, that person is liable. But note, this is not applicable to a generic thing. Why? Bakit kaya? Well, simply because sa generic thing, hindi mo naman kailangang ibigay ang mismong bagay. You don't need to give that specific thing. So, wala kang dapat iingatan dahil ibibigay mo pa. So, if prior to delivery, nasira, na-damage, nawala ang Vios car, which Pogi promised Ganda to deliver, he can always give another Vios car without violating his obligations. Whereas, on the other hand, if the thing is specific, hindi pwedeng ibang bagay. It should be that specific thing. So, prior to delivery, you are, as a debtor, has an obligation to take good care of it. I guess that was clear. Later in this video, I will give you a summary of this topic. So for now, let's proceed to the next article. Na actually ay karugtong lang ng topic na to. Article 1164 provides that the creditor has a right to the fruits of the thing from the time the obligation to deliver it arises. However, he shall acquire no real right over it until the same has been delivered to him. Again, the creditor has a right to the fruits of the thing. Wait, talakayin muna natin ang ibig sabihin ng fruits na ito. Don't take this wrong. The fruits mentioned above or mentioned in this article is a legal term which refers to natural, industrial, and civil fruits. Ano-ano nga ba ang natural, industrial, and civil fruits? Natural fruits, as defined, is the spontaneous products of the soil and the young and other products of the animals. So note, spontaneous products, meaning ito ay ginawa ng walang intervention ng tao. Walang human labor na involved. So at least alam na natin, hindi ito limited sa mga prutas like banana, apple, orange. Ang mga damo sa paligid na kusang tumutubo is an example of a natural fruits. Okay? Well, this is in contrast to industrial fruits. Kasi, ang industrial fruits are those produced by lands through cultivation or labor. So, example of this, sugarcane, rice, tinatanim, merong mga human intervention. On the other hand, the third kind of fruits is by virtue of a juridical relation. Dito yung best example is yung renta. Yung renta ng mga gusali na pinapa, upahan. So, that's it. We are done with defining these terms. Balikan natin si Article 1164. The creditor has a right to the fruits of the thing from the time the obligation to deliver it arises. So the first sentence is saying that the creditor has a right to the fruits of the thing from the time the obligation to deliver it arises. The creditor is entitled to the fruits to be delivered from the time the obligation to make delivery arises. Is it clear? Ang creditor ay may karapatan sa mga prutas from the time the obligation to make delivery arises. Ang tanong, kailan ba yung time the obligation to make delivery arises? If there is no term or condition, then from the time of the perfection of the contract. But note, paano naman ang mga obligation that is arising from law, quasi-contracts, delicts, and quasi-delicts? Kasi hindi naman lahat ng obligation nagmumula sa contracts. In this scenario, the time of performance is determined by the specific provisions of the law that is applicable. So, kung ano yung law na applicable. So, the first sentence now should be very clear. Let's move on to the second sentence. However, he shall acquire no real right over it until the same has been delivered to him. Ang sabi ng first sentence, si creditor ay may karapatan sa fruits at the time of the obligation to deliver it arises. And then the second line says, however, ngunit, he shall acquire no real right over it. So wait, ano nga ba tong real right over the thing? As defined, real right is a right which is enforceable against the whole world. Isang karapatan na kung saan pwede mong ipatupad kahit kanino pa man, as opposed to personal right, which is enforceable only against a particular person. So, pwede mo lang siyang ipatupad laban sa isang particular na tao. Hence, going back to Article 1164, this real right over a property is acquired and transmitted only by delivery. Ibig sabihin, prior to delivery, creditor's right over the fruits is merely personal, and it was only after the delivery that the creditors acquires real right. To illustrate, Pogi sold Ganda, a mango plantation, to be delivered on December 25. Dumating December 25. Pogi did not deliver. Sa halip, dahil nagipit siya, binenta niya ang mga prutas kay Beauty, who is a buyer in good fruit. Ang tanong, does Ganda have a right to the fruits? Yes, as against Pogi. No, as against Beauty. Because Ganda's right over the fruit is only personal, meaning enforceable only against a particular person and not as against the whole world. Kay Pogi niya lang pwedeng ma-enforce ang right niya. Kasi ang right niya is personal only against Pogi. Hindi pa real right dahil hindi pa na-i-deliver sa kanya. So what is the remedy of Ganda? Ganda's remedy is to go against Pogi for the value of the fruits. Simply put, before the delivery, the creditor in an obligation to give has a mere personal right against the debtor, meaning creditor has only a right to ask or demand for delivery of the thing, including the fruits thereof. But once the thing and the fruits are delivered, then he acquires a real right over them. Now, before proceeding with Article 1165, let's discuss first Article 1166. Yung Article 1165 discusses more on the right of the creditor. So, mas maganda na siya sa next video. Article 1166. The obligation to give a determinate thing includes that of delivering all its accessions and accessories, even though they may not have been mentioned. Mabilis lang ito. Natalakay na natin sa nakarang video. But just to discuss in passing. Accessory is anything that is produced or attached to a thing, either naturally or artificially, like the plants in the land. On the other hand, accessories is anything that is necessary for the perfection, use, and preservation of a thing. So Article 1166 simply says, the debtor or obligor is also obliged to deliver to the creditor or obliger all these accessions and accessories. Kasama sa obligasyon ni debtor na ibigay ang lahat ng mga accession at accessories, even though hindi ito na-mention sa agreement unless there is a stipulation to the contrary. Just as a simple example, in buying a laptop, dapat kasama sa ibibigay sa'yo ang charger. Kasi yung charger is necessary for the use of that laptop. Well, before giving you a summary of this discussion, insert muna natin ang obligation to give a generic thing just to complete this topic. Article 1246. Kung ang obligasyon ay may kinalaman sa generic thing na walang eksaktong napag-usapan as to the quality of that thing, ang sabi ng Article 1246, si creditor ay hindi makakapag-demand ng mas mahigit na kalidad and on the same way, hindi rin naman pwedeng magbigay si debtor ng mas mababang kalidad. So, kung ano lang yung dapat, paano ba malalaman kung ano yung dapat? By giving due consideration to the purpose of the obligation at ang mga bagay-bagay na kasama o may kinalaman sa obligasyon. So, that's it. It's as simple as that. And before we forget, in all kinds of obligations, hindi mawawala ang obligation to pay for damages in case of breach of obligation. This is not just applicable to an obligation to give a generic thing, kasama na rin yung obligation to give a specific thing, obligation to do, and even in an obligation not to do. And so, as promised, I will give you a summary of what we have discussed from Article 1163 to 1166, excluding yung 1165.